Hello students, today we will be discussing about right to equality under the Indian Constitution, that is the Constitution of India. Dear students, when we begin to read or understand certain concept, we need to identify three important features or three important parameters. We can say that we need to sieve these concepts through the parameters of what, why and how. Why are we reading the concept? What are we reading under that particular concept, and how that particular concept will be applied in understanding or in the practical sense. Similarly, in this lecture, we will be reading about, we will be understanding the origin and meaning of equality, the jurisprudence behind the term equality, equality and its mention under the Indian Constitution, right to equality and its various constitutional attributes, landmark judgments which are sculpting the concept of equality and right to equality, understanding the potential use of equality in shaping the nation. Why the purpose of lecture is being discussed is because whenever a concept is introduced for reading or understanding, we need to see from where that particular concept is being adopted. What is the need of that particular concept? How do we perceive that particular concept gives us the jurisprudential aspect of that particular topic. So, we need to identify the history, the reasoning which becomes the jurisprudence of that particular concept. Thirdly, we are talking about equality and its mention under Indian Constitution, wherein the concept is being written. There has to be certain text which gives that particular concept a meaning, a recognition, and that is where the Constitution of India comes into existence. The concept of equality holds a prominence in the text of the Indian Constitution, and once we have read that particular text, how do we use that particular provision, that particular law in the current scenario, and how does it is helping in sculpting the nation and the country of India. So, starting with the meaning, the origin of the particular word, the concept, that is equality. Equality comes from a Latin word known as equalis. Equalis means anything which is even, leveled or equal in nature. So, from this term equalis, in ancient and medieval period, it was used as moral, political and social values. These three parameters of moral, social and political values were kept into the parameters, were sieved into the parameters of the equality, that equality should be there or inequality should be there. Amongst whom? Amongst the people living in the society. The ancient periods, only inequality was being considered on the parameters of society, that is societal norms, the moral values. We can be discriminated, the people can be discriminated. But when it comes to the modern concept, the eminent jurists like Thomas Hobbes and John Locke asserted the concept, brought in the concept of natural equality. Natural equality amongst whom? Amongst the human beings. So, this particular concept of natural equality was termed as the social contract theory. Why do we call it a social contract theory? When we live in a society, there has to be a contract between each other for their mutual benefit, and when some people are getting benefited out of another person, there has to be certain parameters discussing the equality and inequality amongst them in order to dismiss all sorts of misconceptions and any of the phenomena which will arise to any of the problems creating by the society. So, the government decided to bring in the concept of equality and developed the social contract theory further, and discussed about what we need as a society is a non-discriminating principle which talks about right to equality. And this particular concept of right to equality can be understood with a very definitive meaning, that is the absence of particular privileges for any group in society, as well as the availability of a suitable opportunity for people without discrimination, which in simple terms means that there should be, if there exists any sorts of privileges which only a particular section of society is getting, we need to discriminate that thing. We should not provide any particular privilege to any particular section of society. There should be privileges granted to the society irrespective of any sorts of discrimination. That terms the word equality in its true sense. Now, moving on to the jurisprudence behind the term equality. So, the term equality is based on the concept that all men are born free and equal. So, when we talk about that all men are born free and equal, it clearly says that everybody should be removed from the bracket of the discrimination, including the gender, religion, caste, race or sex, which we have read very clearly in the texts of the Constitution of India as well. So, earlier when we need to read about the jurisprudential part of equality, it basically relies on the pillars of 6 important facets of equality, that is civil rights, political rights, economic rights, legal rights, social rights and natural rights. But as we discussed, it started with civil, political and economical rights, and then later on it got modified and also incorporated legal rights and natural rights into itself, which obviously broadened the ambit of the concept of equality and improved the jurisprudence of that particular concept. So, when we talk about equality and its mentions under Indian Constitution, we can see that it has been placed in part 3 of the Constitution of India, ranging from Article 14 to Article 18. These rights provide the fundamental rights to the people, starting with Article 14 that talks about equal protection of law and equality before law. Next, Article 15 prohibiting or discrimination on grounds of religion, race, caste, sex or place of birth. Article 16 talks about equality of opportunity in the matters of public employment. Article 17 which talks about the abolition of untouchability, and Article 18 which talks about abolition of titles. Now, why have we read the spread of provisions which has been given under the Constitution of India? As we talked about that equality is a concept and has been extracted from the theory of social contract theory. If we are not discriminating, if we are not getting the titles which makes us more privileged, for example, I am a person who uses certain sort of title and the other person does not use it, and the privileges is being discussed or divided among the titles which have been attached to our names, then the discrimination appears in, and then inequality arises. So, in order to avoid that discrimination, we need to keep these provisions, keep these sentiments in our mind that there should not be any discrimination and none of the privileges should be given to anybody in that sort that it creates discrimination among the society. So, when we have understood the bare concept of equality and where does it place its mention under the Constitution of India, we can see that how does the constitutional attributes give rise to right to equality and help right to equality sculpt the nation. The concept of right to equality is made up of two broad concepts of the jurisprudence, of the administration, of the formation of government. We can say it is being used for sculpting the entire nation. That is the concept of rule of law and the concept of natural justice. When both these concepts come into existence, the rule of law, which means that nothing is above law, and natural justice is that justice which is being given to person, which is a natural right, which a person is born with, is known as natural rights, natural justice. Both of these together form Article 14, that is equality before law and equal protection of law. There are two segments to Article 14 which specifically talks about right to equality, and then further it gives branches to other articles like Article 15, 16, 17 and 18 respectively. So, the Edward Coke, who gave the concept of rule of law, said that no man is above law, and A.V. Dicey in furtherance in its book Constitution of England said that supreme law is supreme in nature and nobody is above law. Taking from here, we can see that no government is supreme, no person is supreme. There must be similar treatment given to everybody in terms of equality and no discrimination should be there, which in turn says that law is supreme. So here if any sort of discrimination happens in the society, by keeping it in the mind, by having the power given to us by the Constitution of India, we can approach the court and say that law is supreme in nature, and according to the law there must not be certain discrimination by mentioning that particular discrimination. Further, when we need to understand the right to equality or the concept of equality, we need to simplify the Article 14 that says the state shall not deny any person equality before the law or equal protection of the law within the territory of India. Here we will be dividing this particular article into 3 different parts. We are identifying 3 key ingredients of it, that is any person. Starting from any person, it says that the state shall not deny to any person. Why do we use the word any person here? Any person means it is for citizens and as well as non-citizens as well. So before the law, equality will be protected before the law and equal protection of the law. These are the 2 other segments of the equality. So here we will be starting with Article 14 clause 1, that is equality before law, which has been taken from the English law. It is primarily considered as a negative concept, and why I am saying it is a negative concept is because it talks about certain avoiding or prohibiting discrimination. When the word prohibition is used, it gives a negative connotation attached to it. But on the other hand, it is prohibiting from what? It is prohibiting from discrimination, which in turn is supporting the term equality. It is a very general law, and we can understand the best example through the example of lady justice. You must have seen it in the courts that there is a lady justice with a band put it in the eyes of that particular lady. Why do we see that? Why that particular band is put before the eyes? Why the sight is being blocked? That is, sight should not lead your judgment. Whatever you see, whatever you perceive should not lead your judgment. A person who is well groomed or belongs to a very well settled family, society, or represents himself or herself or itself to be a very developed person or very influential person should not affect my judgment. On the contrary, wherein there is a person who is deprived of certain rights, we should focus on what is the point of discrimination happening. Is it because of the gender? Is it because of the race? Is it because of any sort of inequality happening in the society? So there should be no unequal treatment, there should be no sight which leads to your judgment, and it should be that discrimination must be made or prohibition must be made in any sort of discrimination happening. Now moving on to the second part of Article 14, that is equal protection of law. This has been taken from the American law, and it talks about the demand. It is considered as a positive concept because we are seeking something out of this particular provision. This part of provision seeks out something. What is that? It seeks out equal protection. For example, the best example for this is the specific laws. We cannot keep everybody in the same pedestal. Like should be treated as like, but unlike should never be treated like. Alright, see, if there are people who have same attributes attached to them, they can be put into the same pedestal. But if for example, there is a person who is differently abled, that person cannot be put in the same pedestal as a person who is very normal. So there has to be that like must be treated like and unlike must not be treated as like. So there must be equal protection for everybody, and there should be certain reasonableness attached to that particular equality which we are providing. There should be no universal application of equality, that when we are talking about equality, gender should be kept into consensus, race should be kept into consensus, caste should be kept into consensus, so that it does not apply universally. Now another important example is that how do we use this particular Article 14 in the application, and how do we identify what should be actually considered under the brackets of right to equality. We are saying that there should be no sorts of discrimination, but then we are saying that unlike should not be treated like. How do we justify this sentence? We can justify this sentence with a two-test theory. There are two test theories which have been incorporated in the modern concept. The modern concept which incorporates natural justice along with the concept of rule of law. As we read earlier, that rule of law plus natural justice gives rise to Article 14, that is equality before law and equal protection of law. So, now the contradictory part is the equal protection of law. So, when we are talking about equal protection of law, this two test theory brings in a major game changer. How does that happen? It talks about two important doctrines, that is the doctrine of rational nexus and the doctrine of intelligible differentia. So, when it comes to these particular two test theory, the Article 14 is being sieved into by or into these two theories, these two tests. When these two tests are being justified, we understand or we perceive that equality is being served. So, here we can say that by the term starting with intelligible differentia, what do we understand by this particular doctrine? Intelligible means intelligent and differentia means intelligent difference of opinion. There should be some intelligent reasoning which needs to be attached when it comes to identifying the equality, identifying the discriminatory or non-discriminatory matter. For example, again we will take the example of the differently abled person. Here we can see that there is a reasonable intelligent reasoning attached to it. There is a reasonable reasoning that a person moving in a wheelchair cannot compete with a person who has perfect legs. That competition or that race, if we put them together, will not be justifiable in any sort. If I give a 5-year-old student, 5th class student, 5th grade student, the paper of 10th grade student and mark them accordingly, will that be a will that account to intelligible differentia? No. Will that give us a justifiable reasoning? No, it won't give us the justifiable reasoning. So, through these examples, we can see that how important it is to identify a reasonableness. That comes the third concept, that is doctrine of reasonableness. So, the doctrine of reasonableness and the intelligent reasoning which is being attached helps the judiciary, helps the lawmakers identify how the purpose and object of certain law needs to be prepared. So, here we can see that equality as a concept is flowing through the veins of all the segments of the government, that is the judiciary, legislature and the executive. Here again we will be seeing that these two theories focus on public welfare. When we talk about public welfare, there has to be classification made in the society, but that classification should be reasonable classification and not class legislation. Here I will be introducing you with what is class legislation and what is reasonable classification, and this will help us understand the use of these two test theory. So, class legislation is something that we again prepare certain privileged section of society, we gather them and we say that these specific rules are only for this privileged people or this class of people or this segment of people, and it will not be applicable to anybody else. So, this is what? This is a class legislation. We have prepared, we have segregated a section of society and keeping that in mind. For example, we have said that anybody who has 5 lakhs plus income will be given the check of 10 lakhs. How does it make sense? It does not make sense. They are already rich, they are already making money, but the people who are actually in need of the money or the betterment is the person with zero amount of money having in their bank accounts. So, that is how we understand class legislation, and that should not be there. So, it is a concept which we should keep in mind that this should not be there. And second part of is that reasonable classification. How do we understand reasonable classification? We have just discussed it now. There has to be certain intelligent reasoning behind whatever classification we are preparing. For example, we are preparing specific laws for women and children. Why do we do that? We do that because they are the vulnerable section of the society. They need growth, they need empowerment, they need help to move ahead in the society. Why do we have laws which are specifically for people belonging to marginalized section of the society, because we need to make them, we need to bring them to that pedestal wherein everybody else is working. So that is how intelligible differentia comes into existence, and there must be rational nexus between what? Here the second theory which we talked about is rational nexus. Whatever reasoning we are giving and whatever the purpose is there has to be a nexus between them, there has to be a link between them. The purpose and the object and the final result must be in consensus. That whatever law I am making, for example, I am making a law which clearly says that women will not be arrested by the police officers after 6 p.m. It's a reasonably, I am classifying it. I am making a law which is creating a difference, but it is not unreasonably difference, because it is protecting the or securing the women of the society. For children, we have separate laws. We cannot treat a 7-year-old person committing a murder and a 50-year-old person committing a murder and keep them in the same pedestal. So there has to be differentiation in that. There has to be reasonableness attached to it. So here the two test theory which I discussed, that there must be a nexus between the purpose, the object and the end result, and whatever nexus will be done will be on the premises of an intelligent reasoning, that is intelligible differentia. And all of this is being guided on the premises of what? Equality. So that none of the person of the society is being deprived of any sort of right which comes from the umbrella legislation of right to equality, that is Article 14 under the Indian Constitution. So here when we are moving or discussing this two test theory, there is one prominent and landmark judgment which we need to read and is mostly discussed by prominent jurists and judges of this country, is State of Bombay versus F.N. Balsara, AIR 1951, SC 318. This gave the first essence to the two test theory, that is doctrine of rational nexus and intelligible differentia. Now, when we have known how the potential use has to be, how how the constitutional attributes work when it comes to equality, we need to see that how equality is shaping the nation, how we can potentially use these test theories and the concept of Article 14 and build a nation which in terms is equal in its self. So, that can be done in two aspects, that is through the letter of the law and through the spirit of the law. These two are very broad and very important terms which I will be discussing right now, starting with through letter of the law. What do you understand by letter of the law? Letter of the law, very simply I will be explaining it. It is Article 14. It can be any other provision which is having a written text, which is in form of written text, which is given in a textual form, that becomes the letter of law because it is in writing. And when it comes to spirit of the law, it talks about the preamble, it talks about the purpose, it talks about the thought which the legislature keeps in mind while preparing that particular law. So, we can say that the spirit of law is hidden somewhere between the letter of the law. It is the judiciary, it is the judicial precedent, it is the judges, it is the lawmakers who extract that spirit from that particular letter of the law. That spirit should be in conscience with the purpose and object of that particular legislation. So, here we are talking about equality, and where equality under the Constitution of India. So, we will be focusing on Article 14, which has a specific letter in form of Article 14 clause 1 and 2 under the Constitution of India, and spirit of law, which we will be identifying by keeping in mind the preamble, the purpose and object of the Constitution of India when it comes to equality. Alright, so starting with letter of the law, fundamental right has been made. Fundamental right is the grand right, it is the grand norm which is within the person, nobody can deny that person from availing that particular right. So, that is right to equality. So, we can use it, it has a potential use in shaping the nation and keeping the equality in prominence, and and the umbrella legislation of Article 14 branches out several legal, constitutional and other rights. How, for example, any of the provision which has been made will be having certain sense of equality in it, that we have discussed already. So, this is how letter of law works, and when it comes to spirit of law, we can say judicial precedents which have helped sculpt the nation. For example, in recent judgments we can see Sabrimala case. Secondly, we can see the decriminalization of section 377 of IPC, which does not eliminate an entire provision, but decriminalizes certain part of it. Alright, we can see the essence of doctrine of reasonableness, how reasonableness brings into existence, how intelligible differentia works, and how the concept of rational nexus work. So, the spirit of law can be seen and understood by various landmark judgments. So, I will be briefing you with certain judgments, because it has thousands of judgments wherein daily we can see that the Supreme Court gives the mention and interprets right to equality. But the landmark judgment which I would like to prominently refer students while reading this concept of equality is Air India versus Nargesh Mirza, which talks about that terminating the services of an air hostess on the grounds of discrimination, that she is getting into motherhood and hence she should be terminated from the services, was considered unequal in nature and it infringed the right to equality. Whereas in recent sense we can see that National Legal Services Authority versus Union of India, here the Article 14 does not restrict the word any person to male, female only. The transgenders are also included in the definition of the person. So, here these are few examples you can see which helps us understand that there should be the rational nexus and there should be an intelligible differentia, making right to equality a full proof right, giving us the prominence in society and helping us thrive through any sort of discrimination. So, dear students, in this segment of the we have read about right to equality under the Constitution of India, but how have we bifurcated it? We have started from the concept of how did equality came into existence, what is equality, what is the jurisprudential part of equality, how does jurisprudence or the history or reasoning of that subject play an important role in identifying a concept that makes it the jurisprudential aspect. So, we have read about how equality came into existence, what is the meaning of equality, how does it traveled, how does it evolved from the concept and made its mention and place as a right, and not only right, the fundamental right under the Article 14 to Article 18 of the Constitution of India, which is the part 3 of the Constitution of India. So, it has become the letter of law from just being a mere concept, and that is being followed and being given to every person in that particular nation depending upon the needs of that particular law which has been created. So, after deciding the jurisprudential aspect of it, we read about where in the Constitution of India right to equality holds its mention. So, we focused on the concept of Article 14, which talks about equality before law and equal protection of law, which is being a positive and negative concept working together, because it is prohibiting certain discrimination and it is demanding certain rights. So, it is going hand in hand. So, it is very important to know us that when we have such good provision, how do we apply it, how do we protect the laws and avoid discrimination, but also do not use it as a universal law. Universal application can make it more discriminatory and inequality arises out of it. So, to avoid that certain thing, we read about two theory test. What was that? That two theory test was intelligible differentia and rational nexus, and both of the concept of rational nexus and intelligible differentia had a common link of doctrine of reasonableness attached to it. So, when we talk about rational nexus, how do we use it in the Article 14? The purpose, the object and the result must be in line, in sync, and there must be an intelligent reasoning attached to any of the reasonable classification we are making, we are preparing in order to suffice the society, in order to grow the society, in order to help the developing nation which India is. So, we cannot restrict it into certain manners or restrict it into certain classification. We need that particular flexibility in that system. When we understood about this particular two test theory, it helped us understand the potential use of sculpting it as the part of the nation and how it is building our nation. That is how well we are sculpting our nation through the potential use of equality as a concept and right to equality, which is derived from the concept of equality. So, we can see major judicial precedents which helped us sculpt the nation, that is Navtej Singh Johar versus Union of India, National Legal Services Authority versus Union of India. We have talked about Mittu versus State of Punjab. All of these things have made us very aware that there should be reasonable classification and there must be certain place which gives us the benefit of doubt that this classification has an intelligent reasoning behind it and might create a rational nexus, and the result which is coming out will be of non-discriminating nature. So, here we can answer all the three questions, all the three parameters are being satisfied of what we are reading, why we are reading, and from where we are reading, that is how we have read it, how we have understood that concept, why we have understood the concept, and how are we using that particular concept where to sculpt the nation, to sculpt the society. Thank you.